I find no difficulty in finding that that bill is unconstitutional insofar as it directs the IEBC on not only the elimination of the number of constituencies, but also the distribution of the proposed new constituencies and the timelines within which to operationalize the same within the constitutional parameters that are given in Article 87 of the 2010 Constitution. The Commission cannot be directed. Article 89 was not even sought to be amended in its entirety. The bill, therefore, is unconstitutional in my finding. On issue number 4, even before I decide whether or not the president can be sued first, it's important to note that there really was no proper service of the process, and the president was therefore not accorded an opportunity to participate in the pleadings in his personal capacity, as he had been sued in his personal capacity. And I find further that Article 143, any interpretation of that article must come to the conclusion that the president or the person performing the functions of the office of president cannot be sued during tenure. And although their immunity is not absolute immunity to impunity, it is nevertheless absolute immunity during the tenure of office. In my judgment, you will see that I have said if any proceedings were begun before assumption of office, they are stayed. That's what the Constitution says, and they are resumed or fresh ones initiated after leaving office. On public participation, issue number 5, I have said where it mattered most, I found no reasonable or any degree of public participation, which is a value in Article 10 of our Constitution that I could consider allowing the standing of the actions that were done without public participation. This court set the test in BAT versus the CS Health, and I find therefore that for me, the test was not met. On issue number 6, the totality of my finding, even considering what the findings in Isaiah B. Watt and in the Katiba case and the effect of the Katiba case on Section 5 were, I would rest with Article 250 of the Constitution and say that the IEBC was not only properly constituted with the minimum number that was required by Article 250, it had quorum, and nothing was shown to the contrary. The last issue, on the last issue as to the referendum question, I agree with all my colleagues in this court and in the courts below that have said that the matter was not ripe. It still is not. The bill never went past the IEBC for it to be submitted to referendum. I find therefore that engaging in a discussion in that matter is a complete waste of precious judicial time, and I would not get myself entangled in such a non-issue as that one. As to costs, this being a public litigation issue, I would say that they lie with each party, and those are the orders. The body of the judgment shall give my explanations for each of my findings. I thank you, Judge President.
Thank you very much. The Honorable already just